Hello, everybody, and thank you so much for joining us again. This is Strategic Solutions, and we're talking about the challenges associated with ADA, FMLA, the Pregnancy Workers Fairness Act, and all of those fun things that you get to deal with on a regular basis. Our focus is HR compliance with industry standards of care. Of course, by doing that, you need to comply with the regulations, but we do that a little bit differently in HR. And when you get a lawsuit, by the way, it's a constructive discharge or wrongful termination lawsuit that may include some actions about the way that you behaved and treated an employee because they think you may have retaliated against them or forced them to quit. But the impact that that has is going to be fully rested in your competency in implementing these regulations. So we talk in this podcast about strategies to manage when these multiple regulations happen at the same time, when you're transitioning from regulation to regulation, and when it gets too complex and somebody made a mistake, and what do you do to fix it? So we're going to talk today about an employee who broke his foot. He broke his foot off the clock. So he broke his foot on 2/10. So let's get down and we're going to add 2/10 to the date to see how many weeks we're dealing with because they're on a FMLA leave. So the FMLA leave was received, and the doctor then released the employee with a statement saying they could return to work. They received the FMLA paperwork indicating that he was going to be off work from 2/10 until March 23rd. And that included a return to work note stating that for 4 weeks he would need light duty. Well, light duty is not FMLA, everybody. ADA is light duty, but we don't do light duty under ADA. If you have a light duty policy, then you'd be implementing your light duty policy. And let's hope that your light duty policy has an end date of 30, 60, or 90 days, that they don't just get light duty till they don't need it anymore. The accommodation that you're talking about now is an ADA accommodation to remove essential functions or the way you perform those functions to provide an employee light duty. That is not done under the American with Disabilities Act. Modified duty with accommodated equipment and potentially a modified change in when you get your job done would be ADA. But light duty and modified duty that takes away the pieces that you need to perform the essential functions of the job is not an accommodation under the ADA, nor do you ever want it to be, because it undermines the intent of the ADA. The American with Disabilities Act is a work regulation, and it requires the employee who's being accommodated to be able to perform all the essential functions of their job at a meets expectation level. If you're performing light duty, are you doing that? If you're performing modified duty, are you doing that? And even in California, if you get a medical certificate that doesn't explain to you that they've got a clear disability and how that disability impacts their ability and what restrictions they have, of course you have the right to get that information. Even in California, everybody, even if your attorney told you you can't. If you need help with that, you give me a call and I'll show you how to do it. If you read the regulation, it clearly says you can also. Not sure why everybody started trading in California that you can't get information to understand how the employee's medical condition impacts their ability to perform all the essential functions of the job at a meets expectations level. And that means we're not doing light duty, folks, under ADA unless that light duty does not remove the method they need to use to perform those functions of the job. Now, you might temporarily modify the way they perform because you have additional employees that can step in easily and not be impacted with them doing their own work. Because if they're impacted in doing their job, then they can't come off of their job to help you with your job. So these are very serious conversations. That's what the undue hardship is about. Let us show you our webpage a minute that talks about undue hardship, good faith meetings, and the ADA interactive process. The ADA interactive process is not to search and research and find out the medical issues from the employee. They need to provide that to us, and we accept what they give us, and we don't need a HIPAA note from it if it's clear. But once we get that certificate, if it's asking us to change the nature of the job, folks, or if it's asking us to change the way we normally do that job, that's probably not a standard ADA accommodation request unless it doesn't impact the operations, the other workers, the customers, the patients, and the way that you get the work done significantly enough that it would cause an undue hardship. That's what the ADA is, everybody. Somehow we've raised it up to a level of let's help everybody figure out how they can do their job and stay working. No, we will do that if you can perform all the essential functions of the job at a meets expectations level. So let's keep going. So they have 4 weeks of light duty. Their FMLA ends on 3/24 because they're released to return to work. So does the FMLA claim end on 3/24 when they're ready to turn to work? Or does the FMLA claim end 4 weeks later because they're going to have to stay on leave because you can't accommodate them under the ADA? It's an undue hardship to provide that light duty. There aren't other employees that could help them. It would impact their job. For example, that would be an undue hardship, and so we would not accommodate that under ADA. However, if you have a light duty policy, of course you apply your light duty policy. And we all remember the UPS lawsuit about pregnant women who wanted light duty as opposed to workers' comp people who wanted light duty. It's our standard for workers' comp to give people light duty, but it's not the American with Disabilities Act. And when you're giving them light duty, you're leaving their job open while they're on light duty, and you're not even addressing the ADA, engaging in an interactive process, or determining whether it's an undue hardship. Why? Because you have a light duty policy that you use, whether it's formal or a standard operating procedure. And then the question is, how long? How long do they get light duty? And my recommendation is it has an end date. 30 days, 60 days, 90 days at the most. And if every time the medical restrictions change, we're going to re-engage you under the ADA to see if we can accommodate those without an undue hardship. And if we can't, we're going right back to light duty if you have the policy, in fact. And you're going back on FMLA if we don't have light duty because we can't accommodate you. So the question was, does FMLA end when they can return to work and they have light duty? Or does it end at the end of 4 weeks? Well, if they return to work, that's not FMLA, folks. FMLA is leave, and ADA, the American with Disabilities Act, is a work regulation. So if they are released to return to work with or without restrictions, well, let's assume they would have restrictions, because if they don't have them, they're returning to work and doing their job normally at a meets expectations level. But if they say, oh my God, I have problems, then you're going to be engaged in an ADA. But if they're returning with restrictions, we're engaging the ADA good faith interactive meeting process. Take a look at the webpage. We start with notifying them that FMLA is ending and they have restrictions and we need to meet with them. And we're going to discuss whether we can even let them come back to work with their restrictions. We might keep them on leave on FMLA for 2 more weeks while they get the information we need. Or if we have it, in this case, we have light duty, but we don't know exactly what those light duty requirements are. We didn't discuss that with the employer, and they didn't provide us that data. But let's assume the light duty restrictions, because light duty is not a definition of restriction. We don't know what that means. The Department of Labor has a definition of that, but none of the doctors use it, so you can't rely on it. You have to have them spell out in detail what that light duty means. So we would give them 2 weeks to spell that out if they only gave us a light duty certificate. And then at the end of 2 weeks, we're going to have a meeting and determine whether we can accommodate that light duty without causing an undue hardship and make sure it's not an unreasonable request. Because if it's an undue hardship and it's an unreasonable request, we are either putting them back out on FMLA if they haven't exhausted. If they've exhausted and they still need medical assistance to do their job, and it's an undue hardship to accommodate them in the restrictions that they have, they're going to lose their job, everybody. Unless they're workers' comp, you might put them in inactive status. But a FMLA transition to ADA is where the lawsuits happen, everybody. In my experience, I've been doing this for 3 decades. I've testified in over 50, 60 cases in court across the country in both federal and state court, and done hundreds of depositions. This is a big deal. We don't take this lightly. If we take it lightly and then impact the employee later, once they sort of thought they were getting accommodated, but we never really quite did it formally, and we never did an undue hardship analysis, you're going to have a really hard time and end up potentially with a constructive discharge claim for retaliation. So understand undue hardship. Understand that light duty, modified duty is not an ADA accommodation. Accommodating somebody to remove things that they can't lift anymore, if it does not impact their ability to perform the essential functions, or you could do it with a piece of equipment or modifying the process in some way, and it does not impact the operation significantly, and it does not impact the client significantly, and it does not impact the other employees, well then yes, we might accommodate you. That's the good faith interactive process. That's the undue hardship analysis. So this question is about when FMLA ends, because the employee has been returned to work with restrictions, and the restrictions are called light duty. When does FMLA end? And the answer is FMLA ends when they can come back to work and perform all the essential functions of their job. Because ADA is a work regulation. If they're trying to come back to work and they can't perform the functions of their job because they need light duty or they need modified duty, we've got to determine if that light duty and modified duty request impacts their ability to perform all the essential functions of the job at a meets expectation level. If you're modifying anything, time to work, anything like that, if they're working half the day because they only can do part of the job but not all of it, they'd be in FMLA for the rest of the day. If they can't do any of it with the restrictions because it's an undue hardship, and you don't have a light duty policy that you have in place that you've been using as a standard operating procedure, which has nothing to do with the ADA, everybody, then they're going back on leave under FMLA because ADA is a work regulation. You must be able to perform all the essential functions of the job at a meets expectation level. That means if there was a performance appraisal, you'd be doing the job exactly the way they need you to. Maybe you're not the shining star, but you're getting the job done. Anything that prevents that would be an undue hardship if you had to allow it to occur, because ADA requires you to be able to perform all the essential functions of the job. That means your standard work hours and all your required deadlines with an accommodation. If the accommodation removes functions, removes the method and way which you perform functions that prevents you from performing it, that's not a reasonable accommodation, everybody. And now we're looking at the undue hardship analysis to objectively document why it's not. And if we don't have a light duty policy, they're going back on leave or they'll be losing their job. And that's the hard stuff, everybody. That's in a nutshell what this is really all about. And we take 2 days trying to separate that out and really nail it down so you can understand what happens when somebody comes back to work and they want to say they can do their job and they've got restrictions that you can't accommodate and have them still perform the functions. That's the ADA, everybody, and that's called an undue hardship analysis. So join us at our trainings if you need some more help with this. Submit some questions if we can help you clarify this, or you've got a complex scenario that you're trying to figure out that maybe you made some mistakes on it and you want get some clarity. We're not attorneys. We don't provide legal advice, but I'm an expert witness in this area and I have been for almost 30 years. So I've had a lot of cases in ADA and wrongful termination and constructive discharge because the attorneys hire me to explain to the jury whether HR failed to follow HR industry standards of care when they implemented FMLA and ADA, especially the transition, the good faith meeting, and the undue hardship analysis, and implementing light duty and modified duty, or if the employee was just trying to play a game. So let us know how we can help you, everybody. Thank you for being with us today.